Hi, everybody. Thank you so much for coming. Hey, Debbie. Hi, Heather. Hi, Jane. Hi, Joan. Hi, Kit. Nice to see you all. Who else? Hi, Marilyn. Thanks for coming. Appreciate you. Hi, Al. Hi, Bonnie. Hi, Terry. Oh, Terry, thank you for coming. Hi, Sandy. Hi, Susan. We're going to get started in about 1 minute. Let's give everybody a chance to get logged in. Hi, Amy. Thank you for coming. Hi, Gwen. Lots of people. This is great. Hi, Yolanda. Hi, Pam. Thank you all for coming. We'll get started in about 30 seconds. Hi, Lisa. Big turnout. Yay. Hi, Barry. Nice to see you. All right. Let's get the show on the road. Put my stuff up. Well, hello, everybody. Good evening and welcome to Social Security, Disability, Change, and Confusion, brought to you by NAMI Cook County North Suburban and Jeff Rabin. Before we begin, I would like to introduce Andrea Lopez. Andrea recently joined NAMI CCNS team of volunteers and will be assisting us with our webinars, providing real-time Spanish translation for the very first time. Welcome, Andrea. We are so happy to have you. Our goal is to be able to provide all of our upcoming webinars in Spanish, so please spread the word. It is new and we are very, very excited about it. So if you would like to listen to this webinar in Spanish, please make sure you are logged in using a computer. Spanish translation will not work on a phone or iPad. So once you have logged into the webinar on your computer, at the bottom where you have all of your tools, please click on Interpretation, which is an icon in your toolbar. Once you click on Interpretation, you will click on Spanish. Please make sure to click Mute Original Audio. To do this, you will hit Spanish icon again in your toolbar and hit Mute Original Audio. This will block out all of the English speakers during this presentation.
Buenas tardes a todos y bienvenidos al Social Security Disability, Change y Confusión, traído a ustedes por NAMI Cook County y North Suburban y Jeff Rabin. Antes de comenzar, me gustaría presentarles a Andrea López, mi persona. Andrea recientemente se unió a NAMI CCNS, equipo de voluntarios, y nos va a estar ayudando con la traducción de este seminario en vivo por la primera vez. Bienvenida, Andrea, mi persona. Estamos muy felices de tenerte aquí. El objetivo es proporcionar todos los seminarios en el futuro en español. Asegúrate de difundir esta noticia ya que es muy nueva. Si te gustaría escuchar este seminario en español, por favor asegúrate de entrar al enlace desde una computadora. Traducción en español no estará disponible por medio de teléfono o tableta. Una vez entres al seminario en tu computadora, por favor selecciona el botón de interpretación. Una vez clicado, selecciona español, ubicado en tu barra de herramientas, y asegúrate de hacer clic en Mute Original Audio. Esto permitirá que solo escuches a la persona que está hablando en español.
Thank you, Andrea. The Spanish translation has been turned on, so let's begin. Hi, everyone. I am Bree Hoekstra. I am the program director at NAMI Cook County North Suburban. NAMI, or the National Alliance on Mental Illness, is the nation's largest grassroots mental health organization providing public awareness, no-cost support, and education programs online and in person, so that people and families affected by mental health conditions can build better lives. We are the lifeline to individuals and families who do not know what to expect in their difficult life journey. We offer classes and support groups and do a lot of local advocacy for mental health. Our programs are free and open to those in our 20 community service areas, but we do not turn anyone away. Our topic tonight deals with Social Security, disability, law, and programs. This presentation was designed as a non-legal presentation where our speaker will review how Social Security analyzes claims and how to prepare so that the strongest case possible is made to the Social Security Administration. According to a variety of sources, including Legal Career Path, hg.org, Disability Secrets, and Social Security Matters, Social Security disability law is the federal law that governs the eligibility and payments of two programs for people who are unable to work due to a medical condition that lasts at least 1 year or results in death. These programs are Social Security Disability Insurance, or SSDI, and Supplemental Security Income, SSI. SSDI is for people who have worked and paid into the system through taxes, while SSI is for people who have low income and resources. The law is based on the Social Security Act, the regulations and rulings of the Social Security Administration, and the United States Code. According to the Disability Benefit Center, there are 8.2 million recipients of Social Security disability benefits, or SSDI, throughout the country. Compared to age 40, and people at or after age 50 are twice as likely to collect SSDI. And compared to people at age 50, people who are 60 are also twice as likely to collect SSDI. According to the Social Security Office of Retirement and Disability Policy, as of December 2020, the number of recipients of SSI was about 8.0 million in the US. Of this total, 4.6 million were between the ages of 18 and 64, 2.3 million were age 65 and older, and 1.1 million were under the age of 18. The need for this type of protection is apparent, but how does one apply for Social Security disability? What should one expect during this process? Our speaker tonight will explain the application process and how Social Security will evaluate each application. He will provide practical hints on what to expect from the bureaucracy, how to communicate with treating physicians, and how to develop supporting evidence. Finally, our speaker will touch on the rules regarding how to return to work while on SSDI for a smooth transition back into the workforce. We will leave plenty of time for Q&A at the end. If you like to type questions in the chat box during our conversation, please do. Andrea will translate your questions if you are asking in Spanish for our speakers to answer. It is an honor to introduce our guest speaker, Jeff Rabin, an attorney licensed in Illinois in 1980, who has focused his law practice in the representation of disabled individuals seeking benefits under the Social Security Act. Mr. Rabin founded Jeffrey A. Rabin and Associates, Ltd. in 1988 and has represented clients nationwide at all levels of the administrative process and in the federal courts. Jeff has shared his experience well beyond his law practice. In April 2012, Mr. Rabin joined the board of directors of the National Alliance on Mental Illness, or NAMI, at DuPage County chapter, and in 2016 became the chairperson of the board of directors, a position he held until May 2021. Adding to his NAMI portfolio, Jeff assumed the executive director position at NAMI CCNS in December 2022. In this role, he will be leading the NAMI affiliates' day-to-day operations and expanding its reach into the community. Jeff graduated from DePaul University College of Law in 1980 and the University of Missouri-Columbia in 1977 with a Bachelor of Journalism degree. He and his wife, Sherry, live in Lincolnshire, Illinois. Sherry is a paralegal in the law practice and devotes much of her professional and personal time volunteering for social service agencies in the community. The rest of their time is spent enjoying their 7 young grandchildren. A frequent speaker on Social Security issues, Mr. Rabin has lectured nationwide to a variety of community, legal, insurance, and government agencies. On multiple occasions, Mr. Rabin has been asked to speak at the annual conference of Illinois Township officials, and he has spoken at several Illinois Institute of Continuing Legal Education and College Bar Association programs. He has testified before the Congress on Social Security issues and was featured in a 60-minute story on this area of the law. He has also had articles published in a variety of different publications. We are so thrilled to have him here tonight to further educate us on this ever important topic of Social Security disability, change, and confusion. I am honored to welcome our guest speaker tonight, Jeff Rabin.
Thank you, Bree. And first of all, thank you, Andrea, for joining our team and for providing this translation. That is a magnificent service, and we do appreciate it. And Bree, you gave so many details. Maybe I don't need to speak much tonight. You really covered a lot of it. But thank you, and welcome, everyone. This is the most fun thing I get to do in my work, either as a lawyer or helping NAMI CCNS on a day-to-day basis. Couple of caveats right at the beginning. Number one, I've developed some kind of a chronic cough, and it's not COVID and it's not anything else, and they don't think it's allergies. It's just there. So if you see me pop something in my mouth, it'll be a cough drop, just to try to minimize the coughing as we go through this evening. Second caveat, I am here tonight with my law firm hat. So I am representing myself as an attorney and my law firm of Rabin and Associates. None of our legal work is endorsed by NAMI CCNS, by NAMI Illinois, or by NAMI National. And so even though I help run the day-to-day affairs of NAMI CCNS, that's not my hat on tonight. So tonight we'll be talking about the law. I will touch a little bit on NAMI and its role and how it can help people, but that's not our main focus tonight. All right, with that out of the way, let's get going because we have a lot of ground to cover. Here's what we're going to do this evening. We're going to talk about what the law is because it's confusing, and we're going to understand what it means to be totally disabled. We're going to talk about SSDI and SSI and go into a little more detail than Bree went in her introduction into the difference of the two programs. We're going to talk about how Social Security thinks about cases, because honestly, they do think about every single case. They just often do it wrong. But we're going to walk you through the steps. We're going to talk about the 3 keys to success, and that'll be the most important slide in the whole presentation, but will give you the information and base you need in order to proceed. We're going to talk briefly about applying and appealing and moving cases through the system, and then we should have enough time, if I speak a little fast, to talk about the most important part of the program. You see, Social Security was never intended to support anyone. Social Security retirement was intended by President Roosevelt to support individuals who are seniors, along with their own savings and community support and family support. It was not intended to be the main living factor for anybody. For Social Security, disability, and SSI, for many, many of our clients, we view this as a time program, giving you time to treat, time to recover, time to retrain, and ultimately time to return to the workforce. And there are very good return to work incentives built into the law, but they're confusing and they're scary. And by the time we're done today, you will understand them and won't be afraid of them and will be able to use them. Many, many, many times when I'm representing a young 22, 25-year-old person with mental illness, I assure them that the day that they call me to say, how do I get off of the program because I'm doing so well and I have this great job, that's when we consider a win. So that's what we're going to do tonight. But before we get started, let's just talk really briefly of how COVID and the pandemic screwed us up, because it's really changed things at Social Security. Basically, it's inverted the backlog. So at this time, if you were to file an application for disability benefits, it could easily be 6 to 8 months before somebody even picks up the file to really begin an analysis at Social Security. Very little we can do about that backlog, absent it being a compassionate allowance situation, which we'll talk about in a little bit. It's just a very bad backlog. And a lot of this came about because during the pandemic, many of the more experienced Social Security and disability adjudicator staff retired or left, and Congress has not appropriated enough money for the day-to-day operations of Social Security. These jobs do not pay a lot of money, and they've had a hard time getting people to take them and train them up. I mean, this is hard work, and it takes a while for somebody to learn it. So initial, easily 6 to 8 months before they even start to do the review. Reconsideration, which used to be a 90-day max, sometimes 120 days, it's 120 days before they even start working on it. They're best basically right now just undertrained and understaffed. Now, the flip of that is the hearing level, which at one point in my career was over 2 years to get a hearing date, has become much more efficient. And that's because they started doing hearings by video on Microsoft Teams and on the telephone. So the hearings are actually being scheduled 5 to 7 to 8 months after you file your request for hearing. So that step has helped move cases more quickly, but it is still a problem that the cases still take too long to process. Unions have worked out agreements regarding reopening, so the offices are open, but I do not recommend people just popping into a local office and hope to see somebody relatively quickly. It's much better at this point in time to still make an appointment before you go into the district office. Because of politics, because of the nature of some of the people who've been in charge of this system, the program has gotten much harder. And nationwide, the denial rates by administrative law judges has gone up significantly. And that's why we do these programs, to help put us on the other side of that denial statistic. All right. What does it mean to be totally disabled? In order for me to get somebody SSDI or SSI benefits, and Andrea, please do not try to interpret this, you have to prove the existence of permanent physical and mental impairment, severe preclusive ability, formerly substantial control activity for a period that's lasted 12 months or result in death. And if Andrea could interpret that, that's amazing. But I said it fast because it's a lot of legal mumbo jumbo. Let's talk about what it really means. In order for me to get somebody this assistance, I have to be able to prove that they are suffering from symptoms which so impact their day-to-day life that they could not function at any type of full-time work available in the national economy for a period that has lasted or expected to last 12 months or result in death in 12 months. Now, I said that very carefully. I did not say that I have to prove my client has bipolar illness or a bad back or a bad heart. Those are diagnoses. Social Security is not focused on diagnosis. Social Security is focused on the symptoms from that diagnosis and how those symptoms impact this particular person's day-to-day function. I get calls all day from people who say, Mr. Rabin, I have high blood pressure and sugar diabetes, and I want to get SSI. And those are very serious conditions. My father passed away from untreated hypertension. But generally, they don't produce symptoms that impact on work. And our response is, those are serious medical problems. See your doctor, watch your diet, get some exercise, and go back to work, because they don't impact on your ability to function in a work setting. People with diagnoses work. People with cancer work. People with multiple sclerosis work. People with bipolar work. But some people are suffering from symptoms so debilitating that they can't function in a work setting. And those are the ones that we try to get SSDI or SSI for. So if somebody calls me up and they have a physical medical problem, a bad back or a bad shoulder or a breathing problem, my questions are all the same. What are the symptoms from that physical medical problem? And how do they impact your ability to do the physical motions of a job? Sitting in a chair, standing, walking, lifting, reaching, pushing, pulling. Those physical motions involved in every single occupation, how are they aggravated or how are they impaired by the symptoms from that physical medical condition? If somebody calls me up at the office and they are suffering from a mental impairment, major depressive disorder, anxiety disorder, PTSD, agoraphobia, an eating disorder, our most common call is bipolar disorder. The questions are still the same. What are the symptoms of that mental impairment? And how do they impact on your ability to do the mental motions of a job? Understanding and remembering simple instructions, interacting appropriately with supervisors and coworkers, dealing with stress or change in a job. Those mental motions that are involved in every single occupation, how are they impacted by the symptoms from whatever that psychiatrist label is? You see, Social Security rarely disagrees with the diagnosis. If a guy's got a scar 6 inches down the middle of his back, he had a back fusion. And Social Security is not going to say that he didn't. What Social Security is going to say is, so what? What are his ongoing symptoms after his fusion? And what can he still do on a sustained basis despite that back fusion? And they call this, in their lingo, your residual functional capacity to perform work-related activities, RFC, and we're going to come back to that a couple of times today. And they develop an RFC for every single person that has applied. And sometimes, actually, by the time we get to see a judge, there might be 3 or 4 different RFCs in the file as the medical evidence is developed and Social Security's internal staff makes different opinions. And then they take that RFC and they apply it to the mythical world of work. And that's where this program, providing benefits to real people with real issues, diverts from reality. In this program, especially if you're under 50, it does not matter whether you could get a job, or whether you get to a job, or whether you'd like the job, or whether the job pays a living wage, or whether there's insurance issues or ADA issues. None of that is going to be considered by Social Security. And if they say there's a substantial number of jobs for somebody in that could be done in Waukegan, and that person's in Joliet, that's the way it goes. Your case is going to be denied. So the focus is not on whether you could get a job. The focus is on how you can function in a job. And let's take an example. And this was a real client in my office. A 49-year-old man was a union carpenter in Chicago, making $43 an hour at that time, union scale, plus benefits. He's climbing the scaffold tips, falls, he hits the ground. He fractured a vertebrae, he herniated a disc, and he needed a lumbar fusion. He's never going to be a $43 an hour union carpenter again, because he's not going to be able to bend and saw all day or throw 2x4s over his shoulder and climb. That's not the test. Social Security is a total disability program. So for us to be successful in his application, we have to be able to prove why he could not work full-time as ticket taker in a movie theater. Sit stand option, you wear a little blue jacket, you rip tickets in half, and you say, I don't even know what movie, Encanto is in door number 2, enjoy the show. Ticket taker at a movie theater, coin changer at a self-service gas station, shoebox packer in a shoe store, washing machine unloader in a laundromat. Social Security has used all these jobs to deny my clients benefits in the past. A number of years ago, I was representing a woman who had been a cardiac intensive care nurse in a downtown Chicago hospital, zapping people like we see on TV and saving lives. She developed rheumatoid arthritis, and this was before the biologics, and she ended up with 2 claw hands. And Social Security denied her application, maintaining that she had the RFC, residual functional capacity, to be a bicycle rental clerk. Back when you could still help substance abusers, and we can't help substance abusers anymore. We'll talk more about that in a bit. I was representing a fellow who was in the Gateway Kedzie house. And at that time, the Gateway program was a 1-year lockdown, learn how to live without drugs program, and very effective. They denied his application, saying that he retained the RFC to be a bank vault security guard. Now, when I told Henry the heroin addict they wanted him to guard the bank vault, he said, "Oh, Mr. Rabin, I wish, get me that job." The truth is, Henry was never going to get hired by a bank to guard the vault. My nurse was never going to go rent bikes. But that's not the test. The test, in order to achieve success, was to be able to prove they could not function or perform those jobs. If I did, I won. If I didn't, I lost. So if you're taking any notes, and you want to write down one word that'll summarize everything that we've talked about, and it's really the heart of the whole disability program, that word is the word do, D-O. Social Security disability cases are all about what the claimant can do in a work setting on a full-time basis, despite their medical impairments. If we can prove they cannot do any type of substantial gainful activity, we win. If we cannot, we lose. Now, this law, proving the inability to function at any type of full-time work, applies to two different programs. The first one is Title II of the Social Security Act, or Social Security Disability Insurance, Workers' Disability, Regular Disability. We're going to call it SSDI tonight. The second program is Title 16 of the Social Security Act, Supplemental Security Income, or SSI. We're going to call it SSI. So we have SSDI, SSI. We're going to start first by talking about SSDI because it's the more comprehensive of the programs. SSDI has two requirements. One, you have to be totally disabled. That's the medical test. Two, you have to have bought the insurance, Social Security Disability Insurance. This is an insurance plan. And this is no different than your homeowner's insurance, than your car insurance, and then your health insurance. Now, I know some of you are kind of thinking, I know I pay my car insurance to State Farm, and I know the boss at the job covers my health insurance. I don't ever remember writing a check out for disability insurance. But every one of you has, because every one of you that has worked made a deal with the boss. And the typical deal with a boss is that for too much stress and too many hours, you don't make quite enough money. Typical boss-employee relationship. The problem is the boss has never kept her end of the deal, because not one of you has ever gotten a paycheck for what the boss promised. Why? Because that paycheck has a stub, and that stub has a bunch of lines on it. The top line on that stub says federal withholding, and that's the money that goes off to Washington, D.C., and it pays for the Army and the Navy and the Air Force and the Smithsonian Institute, and hopefully for improvements in cities and environment and things like that. The bottom line on your check stub, that's a state withholding. And here in Illinois, that's the money that goes down to Springfield. And truly only the Lord knows what happens to it when it gets down there. We know some of it goes for roads and bridges. We know some of it has gone to build a big empty prison sitting in the middle of the state. And we know that not enough of it goes to public education or to Medicaid, which are two other issues that I'm very interested in. And then you've got the lines in the middle for the money that goes over the rainbow to the land of FICAville. Now, I am sure there are a few of you on this call that have a little bit of gray hair like I do. And remember, when our checks actually said FICA, they don't any longer. It's now divided into two lines. One line says OASDI, Old Age Survivors and Disability Insurance, and the other line says Medicare. Combined, those are your FICA payment, and they're matched by the boss. Every dollar taken out of your check for FICA, the boss reaches in her purse, she takes out a matching dollar, and those dollars all go off to Washington, D.C., to the Social Security trust funds. And just a very brief overview on that. No one has an account at Social Security to draw money on. We don't have a pile of money that we can claim. We're not getting dividends or interest on our money. All those FICA dollars go into three big trust funds. The biggest one that eats up most of the money is called Social Security Retirement, and that's what helps our seniors. Then we have a little one off to the side. Now, little is in the billions, so this is all relative, and that's called Social Security Disability Insurance, and another little one off to the other side called Medicare. And that's how these programs work. We work, our FICA taxes are taken out, they're sent up into the trust funds, and then immediately paid out. So those of you who have parents or grandparents or friends getting Social Security retirement or Social Security disability insurance benefits are actually getting the money from the taxes you sent in the month before. And then whatever is left over at the end of the month that is not paid out in current benefits is loaned to the US government. In order to qualify for SSDI, you have to meet a two-part FICA test. First, you had to have paid FICA taxes for at least 40 quarters in your lifetime, or a combined 10 years. Second, you must have worked and paid FICA taxes for 5 of the 10 years prior to the date you became totally disabled. Their lingo is 20 quarters of the 40 quarters preceding the onset of disability. Let's take an example. You're going to learn a lot about me tonight, including my cough. I'm an open book kind of guy, and I'm also a klutz. So since this pandemic started, my wife, who also works in the law firm and works here in the house with me, she learned about this incredible thing that she just loves called Amazon. And she's learned if she just types these things on the computer keyboard, wonderful boxes just appear at the house. And she loves this. And so sometimes I go out there, and one day I go out there and I pick up the box and I trip on my foot and I fall and I bang my head. Now I've suffered traumatic brain injury. She rushes me over to Condell Hospital. They do an MRI and they say, oh my God, he's more brain damaged than he was when he started working at NAMI CCNS. And now I'm totally disabled. I contact Social Security's Waukegan office because I live up in Lake County. And I say, I was picking up an Amazon box and became totally disabled. They look at me a little funny, but the first thing they do is look to see if I've worked at least 40 quarters in my lifetime. And I pulled my earnings record recently, and I'm going to teach you all how to do that tonight. And I've not only worked 40 quarters, I realized I've worked more than 40 years. So I got that one met. Then they say, pull Jeff's earnings records from 2012 to 2022, the 10 years prior to the year that I became totally disabled. And if I worked at least 20 quarters during that time and paid FICA taxes. If I only worked 18 quarters, or I only worked for 3 years, or I worked for cash and never paid the man a dime, I'll have screwed myself because I wouldn't have purchased the insurance. Social Security disability insurance, you pay the premiums by working and paying your FICA taxes. If I've worked enough quarters and I'm totally disabled, I will get a monthly check. The amount of that check is a computer formula based upon how much I paid into the system and how much I've earned over the years. It's a very confusing formula. The average person on SSDI is supporting her family on about $1,450 a month. So nobody gets rich or comfortable on SSDI, contrary to what several people in Congress will say to you. My kids would get benefits up until age 16. They get dependent benefits, or 18 and graduate high school. There's a cost of living increase each year. Last year was the biggest in history. Next year will be much smaller as inflation has been coming down. I become eligible for Medicare 29 months from the date I became totally disabled. Now, this is said a lot of different ways on the street and mostly wrong. So let me again take a quick example. This is July of 2023. And I fell and hit my head today. I'm totally disabled, no issues. I will not get a check for August, September, October, November, December. My first check will be in January of 2024. There's a 5-month, what they call elimination period. We call it a starvation period. My SSDI benefits begin January of 2024. Medicare kicks in January of 2026. 2 years, 5 months from the date I became totally disabled. So that's SSDI, the main program. We're going to talk about a subset in a moment. But let's talk about the other main program, which is Title 16 of the Social Security Act, or Supplemental Security Income. Now, this came about as a result of a series of pictorial articles in Look and Life magazines. And again, I hope that there's a few of you out there that remember those magazines. They did a series of articles in 1971 on the difference in living conditions between the elderly poor in the North, who are getting some help from townships and counties and cities, and the elderly poor in the South who were not and were shown living in shanties and lean-tos and literally using cat food tins as saucers and plates. Congress thought seniors using cat food tins was not a good look for the United States, so they enacted SSI to help the elderly poor and then expanded it to help the disabled poor. 2 requirements for SSI. Number 1, you must be totally disabled. It's the exact same medical test that we talked about earlier. Second, you must be indigent. Indigent for this purpose means no money coming into the household other than possibly TANF benefits or child support, and less than $2,000 in non-excludable resources. Now, what do we mean by non-excludable resources? They will not value the clothes on your back. They will not look at your house. You're entitled to have one house if you're living in it. You're entitled to have one car because you have to go to the doctor and the hospital and the pharmacy. But they will look for money in your purse. They will look for 401ks, 203Bs, checking accounts, savings accounts, U.S. savings bonds, cash value life insurance, poorly drafted family trusts, vacation property, the extra boat, any asset that can be converted to cash. Even if you have to pay a tax and a penalty to access it, counts against the $2,000 limitation. So this program is intended for people who are permanently and totally disabled and with very, very limited financial resources. If you qualify and you're living independently with a rental obligation, you'll get $914 a month this year, plus Medicaid and food stamps. Now, I want to spend a moment and tell a story about a big gap in these programs. And this gap is due to a concept called deeming. Deeming says, what belongs to me belongs to my wife, Sherry. What belongs to Sherry belongs to me. And what belongs to the two of us belongs to our minor children if we still had any. Here's how this impacts. Now, remember, I'm one lawyer, been doing this 40-something years. I'm sitting in one office in Park Ridge. I've averaged this story or called to my office once to twice a week, every week for 40 years. So if this is happening to me that frequently, you can imagine as you spread out across the nation, how big this problem really is. And here's the typical story. Woman goes to college, does well, gets a really good job. She's making money. She meets Mr. Wonderful. He's a great guy. And they get married. Now, this guy is working in the tech industries in the 1990s, and his company goes public, and he gets warrants, and he gets stock bonuses, and he gets cash bonuses, and he's doing really well. And she says, I'm blessed. I get to make a choice. We're fortunate, and I'm going to choose to be a stay-at-home mom. 1, 2, 3 girls. Then we go up into the late 2008, and we have a recession. And then we get into 2010s, and his company didn't keep up with the technology, and they crashed, and he went to another firm and then got laid off. And now he's working with an 8-person firm out in Oak Brook and doing well. But this 8-person firm offers him health insurance. It doesn't offer health insurance for the family. Now, these girls, they've been growing. The oldest one, she's 22, and she's done with college. The middle one is 21 and is a senior, and the baby's 19 and she's a freshman. And they've had all these college bills, and he's not making the big dollars anymore. And the last administration took away the requirement to have health insurance under the Affordable Care Act. She's been healthy as a horse. They don't buy her health insurance. She's 48 and she's hit by a car or develops breast cancer. Or the example we're going to use tonight, she's diagnosed with multiple sclerosis, because that's a pretty common age for women to be diagnosed with MS. And she comes to me and says, Jeff, I'm so weak and so fatigued. Please get me SSDI, and I get a Medicare card, and I can treat at some of the good clinics in Chicago and get my medicines. And I say, no. Why do I say no? Because she's not worked 5 out of the last 10 years at jobs where she paid FICA taxes. She chose to be a stay-at-home mom. And she says, well, okay, I get it. At least get me SSI and Medicaid, because Medicaid will pay for beta-seron, which is one of the entry-level medications, and that'll make sure that I don't lose my legs. I'll be able to keep walking. I have to tell her no. Why? Because her husband's assets and income are deemed to her. He's working. She's not indigent. The United States of America does nothing to help stay-at-home parents, and it could be male or female, who get sick. But that's just part one of the story. Part two, husband looks at her and says, oh my gosh, you're sick. You're not fun anymore. And he's out the door. A huge percentage of our clients are divorced because of the stress medical bills and medical illness place on the marriage. So, but he's been working a long time. He's been in these big companies, and he has $250,000 in 401ks put away. So she hires a good lawyer. And as part of the divorce, she gets half of that for her old age. Actually, if she'd hired my ex's lawyer, she would have gotten more than half, but that's a different part of my life story. We'll talk about that another time. But so she gets $125,000 in her 401k for her old age. That's an asset. So unless she does some very, very expensive and extensive financial planning, or more reasonably, she cracks into the 401k, pays the taxes, possibly pays the penalties, blows it down below $2,000, then we'll give her $914 a month, which, by the way, still leaves her 25% below the poverty level in the United States. This scenario happens every day to people, and it's really a shame, because in a country that screams family values, family values, family values, we value the family, we put zero value on a parent who stays home to raise his or her children. And it's really unfair, but we see this all the time in our office. Now, because this is NAMI, we have one sub-program that I want to touch on really quickly, and that's called Disabled Adult Child Applications. And this applies in a limited range of people, but it moves them from SSI to SSDI, and here's how it works. If the claimant is totally disabled prior to age 22, that doesn't mean diagnosed. That means proven functionally unable to work at a job before age 22, and has a parent on SSDI or SSA retirement, or who died while insured under the Social Security Act, that child can collect SSDI based on the parent's account. It's a much better program in many ways. It pays more money most of the time than SSI. It's not means tested, so people can inherit money or get gifts, and it doesn't affect their benefits. And they also become eligible for Medicare. One downside to this, a person, and I don't understand why this is the rule at all, but a person who's receiving disabled adult child benefits cannot get married unless that person is also a DAC beneficiary. And I have no idea why that is the law. But we look at DAC cases. Now, people call me up and they'll say they're 45 years old and they were disabled before age 22. Not likely that a judge is going back 20 years. But if we get somebody who's 21, 22, 23, we'll look and see whether we can make a DAC application for them also. But remember, their parent has to either be on SSDI, SSA retirement, or who died while insured under the Act. All right, that's the main law. This law is interpreted in the regulations, and the regulations are the fine print. And in the regulations, there's an analytical framework that's used by every single decision maker at every level of the process. Adjudicators, ALJs, appeals council, federal court, they all use the same framework. And they call it the sequential evaluation procedure. Now, I'm a roofer's kid. I grew up with the ladders rattling in the back of my dad's Pontiac and the smell of hot tar, which is still the greatest smell in the whole world to me. I can only say sequential evaluation procedure twice in a day, and my tongue goes on strike. I talk about climbing a ladder because that's how I grew up with those ladders. So let's climb the ladder. First question, this is before we even get on the ladder. There is something in the law called compassionate allowances. about 10 or 12 years ago, Commissioner Astrew said, there are some cases that we just pay all the time. And if we pay them all the time, why are we putting people through all this nonsense? So he started out with 50 conditions. There's now about 220 of them, but most of them are things you'll never understand or never know about. There's names 16 letters long. And there aren't very many mental impairments that are compassionate allowances. These are things that are usually causing imminent death or just aren't going to get any better. And we're dealing with conditions like lung cancer, brain cancer, Alzheimer's, Huntington's disease, Lewy body, things that are really, really severe. And you know people aren't going to get well and they degenerate very quickly. Those are compassionate allowance cases, and those should get paid right away without doing all the malarkey of a typical Social Security case. Assuming we're not dealing with a compassionate allowance, we go to step 1 on the ladder, which asks, is this person working, involved in substantial gainful activity? Make it easier. Are they performing any full or part-time work, which this year generates $1,470 gross in a month? That's the definition of substantial work activity this year. Last year was a little less. Next year it'll be a little more with the cost of living. If somebody is working and making $1,470 gross in a month, it's very unlikely they'll get past step 1. They're going to be denied. There's some ways to manipulate that if there's a lot of work-related impairment expenses to enable the person to work. We call them IRWIs, impairment-related work expenses. But that's really hard to do. Assuming our person isn't working, we go to step 2 on the ladder, which asks, does the evidence document a severe impairment? Now, because this is law and regulations, words don't make sense. So in this case, severe does not mean, oh my gosh, terrible. It means, is there at least a de minimis or a minimal impact on function? And this is where they rule out the sinusitis and the hypertension and the adult onset diabetes cases. The best example of a non-severe impairment is a seizure disorder controlled by medication. Now, seizure disorder, epilepsy, that's really serious. But remember, I said at the beginning that we're not focused on diagnosis. Our focus is on the symptoms. And if those seizures are controlled by medication so that you're not having seizures, it's a non-severe impairment. It doesn't impact on function. Assuming you have an impairment that does impact on function, we go to step 3 on the ladder, which asks, does this condition meet or equal the listings of impairments? Now, the listings of impairments are medical criteria in the law for lots of different kinds of conditions. There's listings for musculoskeletal problems, for cardiac problems, for digestive problems, for pulmonary problems, and there's a whole section just dealing with mental impairments. Very hard to meet the listings. For example, cut my arm off, I do not meet the listings for physical problems. Cut my arm and my leg off, and I'm a double amputee, and I do. So this is a very high threshold. But because it's the first step on the ladder where benefits can be paid, advocates like myself and my team, we're always thinking, okay, what is going to be the applicable listing and how can we meet it? If we can't meet the listing, we go to step 4. Now, what do we know? We know our person isn't working. We know they have an impairment that makes it that does impact on their function, but we know it's not so bad that it meets the listing. Step 4 asks, what is this person's RFC, residual functional capacity? And do they retain the ability to function at any of the kinds of jobs they've done in the last 15 years? 15 years is the past relevant work period. Now, it doesn't mean whether they can get that job. They might have worked at Zenith, and those jobs are all in Mexico. Or they might have worked for the Hallmark lady down the street, and she says, oh my God, I wouldn't have her back for all the tea in China. Not relevant whether they could get the job. The issue is, could they function at any of those kind of jobs? If they can, we are denied at step 4, case is over. If they can't, what do we know? We know our client isn't working. We know that he's got a severe impairment that impacts function. We know it's not so bad that it meets the listings, We know it's bad enough he can't do his old work. Now, considering his age, his education, his transferable work skills, and most importantly, his residual functional capacity, are there other jobs that this person can perform? And this is where we have the fights over the ticket taker at a movie theater and surveillance monitor and sandwich maker type positions. This analysis is used in every case. Every single case was determined based on one of these steps. Now, we're going to spend a bit of time talking about mental impairment and the listings. This is the general categories. Each of these listings is broken down to an A criteria and a B criteria, and some of them have a C criteria. The A criteria is usually pretty easy and not at issue. It's, does the evidence show at least the symptoms to justify the diagnosis? And if we're going all the way to a hearing and we can't even do that, we shouldn't even be at the hearing. So this one usually is not an issue. The B criteria is where the rubber meets the road. Every single mental impairment case is determined by the B criteria, and we're going to talk a lot about that in just a minute. There are some people, many living in supportive housing arrangements with intense case management, some people living in special family situations with intense supports, where if you took them out of that cocoon type living condition and moved them back into the real world, while they're not symptomatic in the supportive environment, they would be very symptomatic in the real world. And if we can prove that, that's a C criteria case. But that's not the typical situation. The typical situation is fighting on the B criteria, and that's the functional question. These are the functional issues involved in every single mental impairment claim. And I'm going to walk you through these because if you or your family member goes to Social Security claiming disability on a mental impairment, these are the only 4 questions that are going to be debated. Not much else is going to matter. First question, when we review the evidence, what does it document regarding this person's symptoms and their impact on her ability to understand, remember, or apply information? Now, this is a pretty high standard, and it applies mostly in psychotic cases and cases with severe learning disabilities. Because to be markedly impaired, if I gave you a list with 3 things on it, you'd have to not recognize that that was a list of 3 things. Or if a boss said, pick up the box over on the table and move it to the bench, you wouldn't be able to understand those 1- and 2-step instructions. If you're so cognitively and functionally impaired that this is a marked impairment, that's very serious to Social Security. If it's not, they go to question 2. And 2, 3, and 4 are the much more common debates. Question 2 asks, when we look at the medical charts and the evidence, what are the documented symptoms and how do they impact on this person's ability to interact with other people? How would she get along with bosses and supervisors and coworkers? How is her day-to-day life impacted? How does she get along with her mom? How does she get along with her dad? How does she get along with her brothers and sisters and nieces and nephews? Is she able to go to family parties, or does she skip weddings and funerals and Labor Day picnics? Does she date? Does she talk to people on the internet? Is she able to go to church? When she goes to the store, does she say thank you to the lady, or does she want to punch her because it took so long? Does she have mood swings? Does she damage things? If there's nothing in the evidence on this, we lose. If it's what they call a mild or moderate problem, and we'll define this in just a moment, that's not a big deal to Social Security because you can operate a punch press and curse at that thing all day. And honestly, the machine doesn't care. All it wants you to do is push the 2 buttons, it'll go whomp and make the piece. If, however, this is a marked impairment, so that it becomes obvious if you were operating that punch press and every hour or 2 the foreman came by and said, hey, how you doing there? And you would take a wrench and throw it at his head and tell him to go away, that's a marked or serious impairment in social functioning. That person would have a much harder time holding a job. And we go to question 3. Question 3 asks, when we review the evidence, how does it document the symptoms and their impact on this person's ability to concentrate, persist, or maintain pace? How is their focus? How is their attention span? Can they watch a TV show all the way through, or do they get ants in their pants and walk around? Are they able to balance a checkbook? Are they able to read something on the internet or on their phone and talk about it? Or do they have to read things 2 or 3 times to get it in their head to be able to discuss it? Are they able to start and finish tasks, or do they start something like the dishes and then go to make the bed and then go to pick up the family room and nothing ever gets done? If there's nothing in the evidence on this, we lose. If the evidence shows it's a mild or moderate impairment, we lose. It doesn't take a lot of concentration to pick up the piece on the assembly line and put it in the box and pick up the piece and put it in the box. If, however, this is clearly a marked or serious problem, and it's being consistently documented throughout the evidence, that's more important to Social Security when they go to question 4. Question 4 asks, when we read the medical evidence, what is it documenting regarding symptoms and their impact on somebody's ability to adapt or manage themselves? How do they deal with stress? How do they deal with change? How do they deal with interaction with supervisors? How do they manage their day-to-day life? Do they get out of bed every day? Do they shower? Do they put on their makeup? Do they brush their teeth? Do they clean their house? Do they walk the dog? If there's nothing in the evidence, we lose. If it's a mild or moderate problem, we lose. It doesn't take, you don't have to look or smell so good to sweep the floor in a factory. If it's a marked impairment, much more serious to Social Security. General guideline in a mental impairment case, to meet the listings at step 3 of that ladder, 2 of these 4 criteria have to be markedly impaired. Now, I'm also noticing that my screen looks very dark. Hold on just a moment. I'm going to take a few steps away from the screen.
Jeff, just to let you know too, we have about 34 minutes left.
I'm exactly where I want to be. Thank
Wonderful.
you. I'm sorry about that. It got darker in here than I thought. Those are the 4 issues in any disability case. Every mental impairment will deal with those 4 issues. They define marked impairment as functioning independently, appropriately, and effectively with a serious limitation in the ability to sustain the activity. Extreme means that that function is totally precluded, and if we can prove that, then you only need 1 extreme limitation. But it's very, very hard for Social Security to find an extreme limitation, most often in a chronic psychotic situation where medications just aren't helping at all. The C criteria we talked about, it applies in just some mental impairment cases, and that's where we document the minimal capacity to adapt to changes in the environment. It doesn't happen often, but when we get that kind of case, it's very real, and we work hard to prove it. So the key takeaway from this, and to again reiterate that word do, Social Security is function driven. How are the symptoms that this person is dealing with on a day-to-day basis impacting their daily ability to understand, remember, apply information, interact with others, concentrate, persist, or maintain pace, or adapt or manage themselves? Now, we get to the big question. How do we do this? I described that this program is hard and that it's getting harder, and judges are increasing the number of denials, and that's all very true. And these 4 criteria were modified a few years ago to make it harder to prove. All was true, but we can win cases. And it's important that we win cases. And now I'm only going to talk about my law firm. I'm not going to talk about general law or other law firms. in my law firm, we turn away about 70% of the people that contact us. So when we take a case, we really believe that person is entitled to the benefits and the assistance, and we're going to fight to make sure they get it. The second reason why we have to win claims and why it's important, it's the only way lawyers get paid. Nobody gives us money up front. Nobody pays us a retainer. Nobody gets an hourly bill for Social Security work. We only get paid if the claims are approved. And just to avoid a question that will come up, it usually does, by statute, the fee in a disability case is 25% of the retroactive benefit check or $7,200, whichever is less. There are some exceptions to that, but they're not very frequent. That's the general law. And any representative that you go to should be using that fee arrangement. Now, how are we going to win this case? 3 rules. Rule number 1, you must be going to the doctor. You must be going to the doctor. You must be going to the doctor. These are medical cases turning on medical evidence. When a new client comes to my office, one of the first things I'm going to say to him is what you say is not evidence because you want the money. As far as Social Security is concerned, you would testify under oath that me as your lawyer still has a full head of curly brown hair if that would get you $1,000 a month. What your wife says, what your girlfriend says, what your oldest child says, what your best friend says, what your priest says. None of that is evidence because those people like you. The only thing that's evidence in a disability case are the clinical charts of the treating specialist. We solicit reports, and it's nice to get a report from a doctor saying, hey, I think this person can't work, but that's not the core evidence. The core evidence are the clinical charts of those doctors. An analogy that I really dislike is people like to think of their lawyer as a gunslinger. I've never shot a gun in my life except a BB gun when I was a kid. And I wouldn't know how to shoot bullets. Well, maybe a rifle, because I've seen John Wayne and I know how he does it. But much short of that, I don't know how to shoot bullets. I shoot case manager notes. I shoot Beck depression inventories. I shoot neuropsychological evaluations. I shoot MRIs. Those are my bullets. And if you're not going to the doctors, there's no evidence. If there's no evidence, we cannot get you this assistance. You must be treating. Rule number 2, though, there's a right and a wrong way to go to the doctor. And because I can't see anybody else, and I know Bree, I'm going to pick on her right now. And you all met Bree Hoekstra at the start of our discussion. She's our program director at NAMI CCNS. And one thing about Bree is she has a really nice smile. Now, I told you all that my dad was a roofer and had a little roofing company. And my brothers and I were blessed. We had wonderful parents, both been gone for many, many, many years, but still my hero and learned a lot. One of the things I learned from my dad, he was a tough guy and he'd be up there on the roof and he'd be using his hatchet to chop off the old roof to put on the new one. And remember I told you about that klutziness thing? I got that from him. So whack, he'd hit his arm with the hatchet instead of the roof and he'd put a gash in it and he wouldn't stop or go to the hospital. The job had to get done. So he'd spit on it, put some tar on it, close it off and deal with it later. My mom would see him say, "Oi, Bobby, you did it again." But that was my dad. He never complained. Whatever life sent his way, my dad dealt with it. And I'm pretty much like that. I don't complain a lot. The other thing about my dad, he was the world's biggest flirt. I mean, my dad flirted all the time. Can't tell you how many times we stood outside a restaurant as little kids. And my mom was with us on the street corner smoking those cigarettes that killed her at 58 and stomping her heel on the ground waiting for my dad. She thought he was paying the cashier. Nah, he was playing with the cashier. And it was all in good fun. And he taught me how to be a good flirt. And I do it pretty well. And my wife, at least this one, she understands me and everything's pretty cool. Now, Bree with the nice smile, she's my psychiatrist. And today's my day to go in and see Dr. Bree. So what do? I do the same thing every one of you do. I take a shower, I put on a clean shirt, I shave what I want to shave, I pat down what's left to be patted down, and I walk into Dr. Bree's office, and she says, "Hi, Jeff, how are you today?" And I answer her the same way you all do with your doctors. "I'm okay, Doc, how are you?" And what does she put in her chart? "Well-groomed, nice man says he's okay." Now, she and I both know I'm okay relative to a really lousy baseline, but she doesn't put that in her chart. She just says, "Well-groomed, nice man says he's okay." Next month I come in. Now I'm a little disheveled and my eyes are red and I have this thing that the mental health people call a flat affect. I always think of the iron piece on a Monopoly board, but it means I look sad. And Doc Bree says, "Hey, Jeff, I'm a little concerned. Any new symptoms? Maybe we need to adjust your medications." What do I hear? Adjust my medications. Now, everybody in this chat has probably dealt with somebody in mental health medications, and we know how much people hate to change their medications. "Oh, no, Doc Bree, really, there's no new symptoms. It was just a tough week. The dog pooped on the carpeting. My car I had a wheel taken off. It was a whole mess. It was just a bad week." What does Dr. Bree put? Jeff says no new symptoms. Next month I come in. Now I'm a mess. The clothes are dirty and I haven't taken care of myself. And when I walk in, she has to take that Febreze bottle that she keeps under her desk and give it a couple of squirts because I haven't been taking good care of my grooming. And she says, "Jeff, are you sure things are stable? I'm concerned about you. Maybe we need to talk about that day hospitalization program over at Evanston Hospital." What do I hear? Hospital. I've done Evanston. I've done Good Samaritan. I don't like mental health hospitals. I've done Chicago Behavioral. I don't want to go back there. "Oh, no, really, Doc Bree, there's no problem. I'm stable. It's just another bad week. I got in a fight with the school principal because he said my kid didn't hit another kid, and I said my kid wouldn't have done that. Just a bad week. Really, I'm stable." What does Dr. Bree write down? Jeff says he's stable. Every note from your psychiatrist, your therapist, your family doctor, your emergency room doctor, your OBGYN, your back doctor, every note is going to be read. And what do they read here? Jeff says no new symptoms. Jeff says he's stable. Jeff says he's okay. Okay, case denied. I've lost cases because my clients lie to their doctors. Now, I lied for good reasons. I don't want to complain. I don't want my meds changed. I don't want to go to the hospital. That's all valid. But two things happen when you do that. First, Brianna is an outstanding psychiatrist, but she is a lousy mind reader, and she's not following me around with a camera. And if I do not discuss with her what's really going on in my life, she cannot make good medical decisions for me. So I am not going to get good medical care. Second problem, she writes down inaccurate things because that's what I'm telling her, and I'm going to lose my chance to get benefits I'm entitled to. So when you go to the doctor, you must be telling the painful truth. If you cry, you cry. If you curse, you curse. If you pound the table, you pound the table. But you have to let the doctors know what's going on. It's the only way you stand a chance of getting better, and it's the only way we can document what's happening with you for your disability case. Rule number 3, Social Security wants specialists. Seeing the family doctor and getting a prescription of Prozac is not evidence for a mental impairment. If it's a mental impairment, you must be treating with either a combination of psychiatrist and social worker or therapist, or alternatively treating with a good PhD or PsyD psychiatrist, or psychologist, excuse me. And the reason why with the psychiatrist we insist on the therapist is many psychiatrists today basically do medication management. Are you homicidal? Are you suicidal? How's your sleep? And here's your meds, and come back in a month. And it's a 10 or 15 minute visit. And that's not telling me, are you changing clothes and can you watch a TV show and how you're getting along with your niece and nephew? That's where the therapist comes in. On the other hand, psychologists usually do spend a good hour with people and get a lot more detail. If your case is a cardiac case, you've got to be seeing a cardiologist. If it's a back pain case, you've got to be seeing an orthopedic or a neurologist or a pain management doctor. If it's fibromyalgia, you must be seeing a rheumatologist or a pain management specialist. Social Security wants specialists. So if you're seeing them regularly, if you're describing your day-to-day limitations and problems and you're seeing the right people, that's how you create the evidence to support a disability claim. It's all about the charts, my oldest grandchild, Mason, is 7, and he loved that song. It's all about the bass, about the bass. So this slide was actually in his honor. The charts mean everything. When we get charts that have words like mild or moderate or stable, when we have to prove marked impairments, those words make a difference and often hurt our cases. Let's go here. 1996, Congress changed the law. It was during a compromise between Bill Clinton and Newt Gingrich. And one of those compromises was eliminating substance abuse as a basis for disability. The test is if it's a material factor, benefits could not be awarded. Would the claimant be totally disabled if they stopped using drugs and alcohol? If the answer is no, they'd be functional. They're not entitled to benefits. So when somebody comes to us with a history of substance abuse, we'd like at least to see 6 months clean time, documented by the psychiatrist and the counselor, along with their notes showing how mental health problems are still very prevalent and disabling, even after they're no longer on substances for a while. Applying and appealing. We actually do applications for our clients now in our office. Most law firms will do that. Not all, but most will. You file basically online is the easiest way. And then your case gets turned over to the states. The states do the first 2 levels of review. That's at the initial application and reconsideration. And those reviews are done by people called adjudicators who work for the State Disability of Adjudication Services. At the initial application level in Illinois, 35% of the cases are awarded, and that's the obvious ones, the brain cancers, the double amputations, the heart transplants. 65% get denied. When you go to the reconsideration level in Illinois, 90% of those cases are denied, only 10% are approved. If you lose there, you get to the hearing before the administrative law judge. This is the most important step in the process because it's the only time that you see and talk to the decision maker. Everything up to this is done by phone and mail. Everything after this is done by phone and mail. If you lose in front of the administrative law judge, you can file an appeal to the appeals council. You do not get a new hearing. It's all based on the evidence that was introduced at the ALJ hearing and in those judges' findings. The appeals council only remands about 8% of the cases. 92% of the time, they support what the judge did. And if there's still very severe error, you can now sue Social Security in federal court, in the United States District Court. You sue the Commissioner of Social Security, and you get to argue in front of the district court judge or the U.S. magistrate. You do not get a trial. You do not get to testify. It's based on written arguments, all focused on what happened at the ALJ level and the evidence that was in the record at that time. So that hearing level is really the determinant part. It's the linchpin to the whole process. These days, most people retain advocates before they even file, because then you learn the law, you learn what's important in your case, and you have the most amount of time to develop the evidence, so you have the strongest possible case when you get to the administrative law judge hearing. All right, let's change gears. And Bree, this will take me about 8 minutes or so, and then we'll have time for a few questions. Some of you are already on disability. So what's going to happen? Number one, you're going to get reviewed. Everybody gets reviewed. You never know when you're going to get reviewed. Every favorable decision is secretly coded by Social Security as to when they expect there to be medical improvement, and then you'll get reviewed. The test in a review is there medical evidence of medical improvement sufficient to allow this person to return to work? So here's what happens. I represented Bill, And Bill was stubborn and he refused to go to the doctor. And I yelled, go to the doctor, go to the doctor, go to the doctor. He went to the doctor. We won. I'm no longer talking to him because we won, and he stopped going to the doctor. And then he gets a letter. He blows that off. He finally gets a call from Social Security saying, hey, I'm an adjudicator. I'm doing a continuing disability review. And I want to know if there's medical improvement sufficient to allow you to return to work. And you remember these are medical cases. So tell me who your doctors are. And Bill says, well, I haven't been to the doctor in a year. And a big smile comes to the adjudicator's face. And he says, don't worry, I'll send you to one of mine, buddy. And he goes out for a consultative exam, and the consultative exam says, how many fingers am I holding up? What's the difference between an apple and an orange? Count backwards from 100 by 7. Name 3 cities. Oh, you can do that. There's medical improvement, case denied, and you're terminated. So if you're on benefits, the rule is you must be going to the doctor, because we do want you to get better to get to the next step. But if you're not, it has to be documented. But let's say you are. You're better, you want to go back to work. How do you do that without getting in trouble? First, are you on SSDI or SSI? Because the rules are different. Start with people on SSDI, 3 benefits. Benefit number 1 is the trial work period. Trial work period's cool because, excuse me, I'm so sorry. It allows you to work and collect benefits at the same time. So you can go get a job and earn $2,000, $3,000, $4,000 a month and still get your Social Security disability insurance check. So cash flow is excellent. You're allowed 9 months of work. Now, it would be easy if it was 9 months in a row, but that's too easy. So the way they define 9 months is 9 months out of any 60-month block of time. So let's take an example. Somebody goes on disability in 2015. They work 3 months in 2019, 3 months in 2021, and 3 months in 2022. That's 9 months, 2019 to 2022. It's less than 5 years. They work 9 months. They've used up their trial work period. Now, let's take that same person who went on disability in 2015. She worked 3 months in 2016. She worked 3 months in 2021. And she worked 3 months in 2022. By 2022, those months she worked in 2016 are outside of the 5-year slice of time. They don't count anymore. So you have to watch how much you make and when you make it to see whether you've used up your 9 months. The easiest way is always contact Social Security and ask them. This year, you use up a trial work period month. Any month where you earn $1,050 gross in a month. Last year was $970 gross in a month. So it changes with the cost of living. But there's a second benefit, because 9 months for somebody who's permanently and totally disabled with a long-term chronic illness, 9 months doesn't really tell us a lot. Conditions go into remission. So the second benefit is called the extended period of eligibility. And this says, okay, you've done your 9-month trial work period. If you're continuing to work and now you're making more than $1,470 gross in a month, you're not going to get a check for that month. But if at any time in the next 3 years, you become unable to continue working and making $1,470 a month, right back on the program, no questions asked. So you're protected for the 9-month trial work period and for another 36 months after that. The third benefit is you get to keep your Medicare. Remember we talked about Medicare way back on SSDI? You keep your Medicare through the whole trial work period. You keep your Medicare through the extended period of eligibility for 3 years, even if you're not getting checks because you're over $1,470 a month. And you get to keep your Medicare another 4.5 years after that. This was really important in the past, before the Affordable Care Act, when pre-existing conditions were a bar to access to health insurance. And you would think it's not as important now, but we all saw a few years ago how close the Affordable Care Act came to getting repealed. And if it wasn't for John McCain doing this, we would be back with pre-existing condition problems. So this extended Medicare is still an important benefit. If you're on SSI and going back to work, this is a little different. It's a math formula, because remember, SSI is means tested. Income makes a difference. So let's pretend, we'll pick on Bree again because her name's in front of me. Bree goes back to work on SSI and she does Mary Kay sales and she makes $285. The way it works is they take away the first 85, that's excluded. 65 for one reason, 20 for another. Those numbers have not changed since 1979. Then after that, they reduce her SSI check by $1 for every 2 that she earned. So she made $285. We take away 85. We're left with 200. Half of 200 is 100. So the following month, she'd only get 814 instead of 914 in SSI. But 814 plus the 285 she made, she's still way ahead of the game. The key to going back to work on disability is avoiding overpayments. And the way to do that is you must report change in circumstances. You move, report it. You get a job, report it monthly with your check stubs. You get married, report it. How do you do that? Well, you can dial Social Security's 1-800 number and you'll hear Mrs. Smith on the phone and she's typing. Is she typing in your information or is she writing a letter to her sister? You'll never know and you'll never find Mrs. Smith again through the phone system. So the best ways, if you are on SSI, there is an app for your phone called the Social Security Mobile Wage Reporting app. And you can report changes right on that app. And then you get an email proof and you can prove that you reported. If you're on SSDI, you go onto Social Security's website at ssa.gov. You open up a My Social Security account and you report there. That's the best way to report because you have to be able to prove that you did it to avoid overpayment issues. Now, first, I hope those of you that have come to each of these webinars, and I think this is the 5th one since Bree and I became part of NAMI CCNS, there's a lot of work in doing these. And our team of Brianna and Heather and Courtney, David, and Molly, they do a lot of work, especially Brianna on these webinars. So I want to thank you. And please, now I'll take off my law hat. NAMI makes a difference. We do this because we see each and every day how many lives we impact and how many lives we can change by providing the services that NAMI provides. Many of you have been the beneficiaries of those services. Please stay involved with us. Volunteer, come to our programs, call and say hello. If you can donate, donate. If you have ideas, send them. We are so anxious to grow and expand the reach of NAMI in Cook County North suburbs. We look forward to coming into the office every single day. And we look to continue to doing that, but we can only do it with support. We don't charge for our programs. So we have to really work hard to make sure that we can put these programs out there like this webinar and help people. So Brianna, thank you for setting this up today. Just a couple of things. There's my law firm website, rkblegal.com. There's a lot of information on there, and you can also contact us through that. The main point on this slide is the last one. If you have not done this, go on to ssa.gov and make sure it's .gov and go to My Social Security. It's about a third of the way down the page and open an account. You can check your earnings record. You can see what your benefits will be. Very important. There's my contact information. You don't have to hire my law firm to ask questions. Just send me an email, call the office. I have an incredibly strong team, both at the law office and at NAMI CCNS. I'm very, very blessed to work with the talented people around me. So we will always be available to support and just answer questions. And with that, Bree, if there's questions in the chat, I'd be happy to answer, and I'll stay on as long as people want to listen.
Yes, thank you, Jeff. We really appreciate you providing all this really important information. And we do have some questions in the chat, so let's get that conversation started. The first question says, I am partway through applying for SSI and my young adult daughter online. Yesterday, I received a packet in the mail asking my daughter to finish applying through the mail. She has extensive medical records, which I would prefer to send electronically. Do I need to continue with the paper application, or can I finish her application via the SSA website? Thanks.
Social Security likes wet signatures on SSI applications, so just finish it on paper, keep a copy and send it back. That'll be the fastest way. Don't worry about sending in the medical records at this point, because nobody at Social Security's local office is going to look at them. No one's going to look at them at all until it gets to an adjudicator, and you'll get a letter from the adjudicator who's going to send out an activities of daily living questionnaire and a work history form. We call that ADL, the activities of daily living questionnaire, the killer form, because it can often make or break the outcome of cases. But just go ahead and finish it on paper and get it done. That's the most expeditious thing to do. And then you'll submit the medical records as soon as you hear from an adjudicator.
Thank you, Jeff. Next question says, for SSDI, do they also look at 401ks and pensions as they do for SSI?
No, SSDI is not means tested because you paid for the insurance. The best example I give is the bank owner who runs his Volvo into a tree. The insurance company doesn't ask if he has enough money in the bank to fix it. They say you paid the insurance and we'll take the car over to Joe's body shop and we'll fix it, even though you own the bank. You paid for the insurance. SSDI, you bought the insurance. It's not means tested.
Thank you, Jeff. Next question says, I have an adult child who is in a long-term mental health care facility. He has been there for about 1 year. It is paid for by Medicaid. He may be capable of living in the community with a lot of supports, assuming that the medical records from the long-term care facility and the past providers support getting disability benefits. Can he apply for SSI while living in a long-term care facility?
Yes, but the way that works is the money is diverted to the nursing home or the care facility. So the SSI could get approved. He'll get $30 put into his account, and the balance of the money goes to the facility to pay for his expenses. Then when he leaves the facility, he can arrange to have the money reinstated and sent back to him instead of the facility. Sometimes that's a paperwork nightmare. But if you're getting care in a facility like that, they actually get the SSI. But it's important to do because you want to do it while he's still in bad shape, not when he's looking better because he's lived in the facility for a year.
Thank you so much, Jeff. Okay, a couple more questions. I have an adult, oh, we just read that one, sorry. Next question says, can you speak to the similarity of applying for disability if you have worked for the railroad? Can you get disability through the railroad disability program? Do you know if it follows the same rules, et cetera, as SSDI?
So yes, it does. Railroad retirement follows the same definitions of disability that are in the Social Security disability regulations. The decisions are made through the Railroad Retirement Board system. They have their own reviewers and judges there. You do not use the Social Security personnel. There are other requirements like how long you worked on the railroad. I've done a few railroad cases in the past. Not very many. It's its own world, but the disability tests are the exact same as what we've talked about for Social Security disability.
Next question says, my daughter has a disability and she is 17. What is the best time to start the application? And is there resources for families who cannot afford legal services?
All right, so two different questions there. SSI is means tested. So the parent's assets and income are deemed to the child until she reaches 18. So you can't file at 17 unless there's very, very limited income and financial resources with the parents. If that is the case, then you could file with her as under a child's disability. But when she hits 18, it's going to be reverted back to the adult disability and determined under those rules. So probably in this situation, best to wait to file till she's 18. But here's why these talks are important. typical scenario, and I have no idea if that fits this particular family, but this is, again, my typical phone call. Child starts manifesting mental health symptoms in middle school, 13, 14 years old, lots of angst, lots of nervousness, lots of treatment. Things go on, they migrate up to high school, things stabilize a little bit, the family gets exhausted, money becomes tight, the school's providing some social services, so parents kind of let things slide. Then we hit 18 and the family wants to apply for SSI, and I say, okay, well, where are the medical records showing how well he functions around other people and how his concentration is? And they say, well, we haven't really been treating, he's been getting social service through the school. Those notes are sometimes helpful, but often not. So if your daughter is 17 and you're anticipating applying for disability with her, make sure that now she's under the care of either the combination of the psychiatrist and the therapist, or alternatively the PhD or PsyD psychologist, so that the evidence will be there at age 18.
Thank you, Jeff. And it is almost 8:30, so we can't stay on for additional time, but I do want to provide some information to those who do need to leave at 8:30. So I'm going to quickly provide that, and then we can stay on for 15 more minutes or so and answer some questions that you may have. So tonight, if you enjoyed tonight's program, you can find more information about upcoming programs and events at www.namiccns.org. Our next program will be held on August 30th from 7 o'clock to 8:30, where Nancy Sussman and myself, Bree Hoekstra, will provide information on NAMI CCNS's current programs and outreach initiatives. Once you log off, you will see a short survey that will both allow us to better understand your comfort level with today's topic, as well as provide us with information we need to raise money to continue providing free mental health services in the Cook County North Suburban area. So thank you so much for those of you who have to go. We appreciate your attendance. And if you would like to stay and get some questions answered, we can stay for a few more minutes and get some of that answered for you. So I am going to move on to the next question. It says, my son is on SSI, but can now be eligible for SSDI under my work record. Is the decision process different for someone who has already been deemed totally disabled under SSI?
It used to be, because if he's disabled, and if it was before age 22, it used to be automatic. Now it's not. You have to file a whole new application and you have to go through the whole process. So if your child was put on SSI before age 22, we still you need to file a disabled adult child's application, and they're going to send it to an adjudicator for review. This was a change that was made several years ago for no reason other than to screw people up. I mean, I'm sorry to be blunt about it, but there was no other reason for it. So yes, you'll have to file an application.
Thank you, Jeff. Next question says, can you tell me anything about ABLE account? Is it a good thing to app for?
Wow, excuse me. ABLE accounts are wonderful. And they're part of the Special Needs Trust. We had Paige Fox talk about this, and Missy Foreman talk a little bit about this a couple of months ago. But ABLE accounts allow a family, I believe it's $14,000 a year, to put into an account for somebody on SSI, and it does not count as a resource for that person. And they can use that money to help meet fundamental needs, like they need a computer for school, or they need a new winter coat and their SSI doesn't cover all of it. They're allowed to accumulate up to, I think this year the number is $102,000 with growth if the money's invested in stocks or whatever. So ABLE accounts for families, even if you can't put in $14,000, if you can put in $1,000 or $2,000, it does set aside some money for their child if they get better, to help them get to work or become independent or get a better place to live, something like that. It should always be done with a special needs attorney, looking at the overall situation. So somebody like Paige or some of the other really, really top-notch special needs lawyers around our area, or a very good financial planner who understands this, not all of them do, to be involved in this discussion. And if you need referrals for people like that, just contact my office and we can help.
Awesome. Thanks, Jeff. Next question. It says, thank you so much for this pertinent information. My son receives the SSDI, and we just received his package for recertification. He has been disabled since 9 years old, years being disabled, and let me reread that. He has been disabled since 9 years being disabled, and last year fully disability and Medicare given to him. Every 3 years, he has an episode. He doesn't like hospitalization, but went recently and is getting better and tolerable. This is a lifelong journey. All of my family members have died, so I will be relying on community members for documentation. Will this be acceptable?
No, it's the psychiatrist and the therapist. Community members, family members, they're not evidence in a disability case. So, and an episode every 3 years is not a totally disabling limitation. Your son needs to be under the regular care of a psychiatrist and a counselor, and that's where Social Security is going to look for evidence as to whether or not there's been medical improvement sufficient to allow him to return to work.
Thank you so much. And I'm just responding to one of the questions. Awesome. Next one says, my adult son has been receiving SSI for 5+ years. Is he automatically eligible for Medicare? Do not want Medicaid. And should he apply?
SSI does not, very careful, does not give you Medicare. You only get Medicare if you're on SSDI. So on SSI, he's only eligible for Medicaid or purchasing health insurance under the Affordable Care Act. But if his only income is SSI, the Affordable Care Act is going to send him back to Medicaid. Fortunately, in Illinois, we are one of the states that had a governor that was smart enough to pick up expanded Medicaid. Not every state made that decision for reasons which I will never understand. So as long as your income is under, I believe that number is about $18,000. In Illinois, you get Medicaid, and if you're on SSI, you get Medicaid. There is generally in our area some access to mental health treatment on Medicaid, not a lot. The DuPage County Mental Health Department, the Lake County Mental Health Department will take you on Medicaid, and both of those provide good services. Will County also. Cook County is harder, but in our area, we have the Ecker Center, we have Joslin, we have Turning Point, we have Trilogy. It takes some phone calls and some wait lists, but you could find the one in Elk Grove Village. I'm mental blocking the name of it. That's terrible on my part. I'll think of it. But there is some mental health treatment on Medicaid.
Wonderful. Next question says, does I'm thinking this is SSI, maybe not. Does SSA take into consideration medical treatments that are weekly, like once a week, and takes a full day in a person's functioning?
So the answer is it depends, because the judge will say, do it on Saturday. So that alone is usually not enough. Now, somebody who requires infusion treatments, that's usually what this is, that are that extensive and that frequent, usually are having a lot of symptoms. So you'd focus on the symptoms, not on the treatment. It's very hard to get doctors to say that medications make people unable to work. I can't even get oncologists these days to say that chemotherapy stops people from working. So we very rarely focus on the side effects of medication or treatment. We focus on the symptoms from the disease.
Thank you, Jeff. And we actually had somebody respond to the last question saying Kenneth Young Center and Threshold
Thank you.
take Medicare, or
Yes.
I'm sorry, Medicaid in Cook County.
Thank you. Absolutely. Thresholds is an outstanding program. Really good people there. Kenneth Young Center is an outstanding place. Their backlog to see the psychiatrist is lengthy. When Governor Rauner closed many places through some of his actions, we lost the main center, which put a huge burden then on Kenneth Young, and their caseload increased dramatically, but they provide really good services there. And there's other places you could find treatment, through Catholic Charities sometimes, or through some of the other agencies. And our team at NAMI can help you with that sometimes to find places. But we're lucky to be, like I say, in a state that has expanded Medicaid.
Great. Let's see. Backing up. What does this process look like as we come to your law firm for help? What are the typical beginning steps?
So again, I'm only going to talk about how my office is structured because it's different than anybody else. You call my office, generally you're going to talk with one of my intake people. That's primarily Kelly. Sometimes you get me if Kelly's busy or on the phone. But Kelly generally does a screening to make sure that there's really a theory. If there is, she'll then set you up with a Microsoft Teams or phone interview with either Susan or myself. Susan does most of these because a lot of my time now is tied up with NAMI. I do about 20%. And there we'll go through all the law and the detail and the education. We actually feel that first meeting is the most important thing we ever do for a client. Because if we can teach you how to develop good evidence, two things happen. You're going to have better medical care because you're going to be communicating better. And secondly, we'll have strong records so that when we get in front of a judge, we don't have to be Clarence Darrow because we can just point to the good records. So Susan or I make the final decision on taking the case. You then electronically sign our retainer agreements, and then the file goes to the team to do the application. That's usually Leslie or Sammy. And then after that, it goes to my paralegals who handle the first two levels of review, initial and reconsideration. We have multiple ways for you to stay in touch with them. And if we don't win, then we go to the hearing level. You get a new team at the hearing level, which is run by my wife, Sherry, and then two of the hearing paralegals and our 3 trial attorneys. That'll take you all the way through the process with our firm. Really good people. I've got some of my people who have been with me over 20 years. They really know their stuff.
Thank you, Jeff. This one says $1,050 gross, in quotes, refers to TWP W-2 wages. But what is the TWP metric for 1099 gig work? Monthly net profit after business expenses and medical premiums?
Not medical premiums. These become much more challenging. So the answer is yes, Social Security will look at the gross wages and they will look at the business expenses to see if you're below 1,050. But you're not writing off your bedroom in your house as your office, and you're not writing off gasoline in your car when you're also using that car to take the kids to school or go to the grocery store. This is pretty strict. It becomes a fact question, so it's hard to generalize, but it is net business profits. There's a second test. Social Security will also ask if you weren't the business owner, but you were doing this work for somebody else, would the value of this kind of work be over 1,050 a month in the general business community? If it is, it could be treated as SGA, or it could be treated as a trial work period month. It's a really tough question because there's a lot of facts that get involved in that.
Thank you, Jeff. Next question says, I have a child with assets that have been put in an OBRA payback trust. We have a joint bank account that I deposit $50 per week into for his use for eating out. Does this create a conflict with the 2,000 limitation for SSI?
So if you did an OBRA trust, you found a really good lawyer who knew what they were doing, because not all of even the special need trust lawyers like to do OBRA trusts. So that's very good. I would not do $50 cash. I mean, it's $50. It would be considered income. It's not going to make a big difference in his ultimate benefit. But another way to do that is give him a credit card or a debit card with a $50 or $100 limitation, and then just pay the credit card directly. And that way you can still allow him to go out and have a little control over what he does. And it doesn't count as income. For $50, it's not the end of the world.
Thank you. Let's see. Maybe you can understand this question. It says, for SSDI and SNAP programs and disabled adult child, ?
3 different programs. Disabled adult child, you have to be disabled before age 22 and have a parent on disability, retirement, or who passed away. SNAP is a state program. And then SSDI, we spent the whole evening talking about. You should be eligible for SNAP depending on the amount you get in SSDI. I do not know the financial limitations on SNAP benefits.
This might play into that question. It is from the same person. She says, can I get max amount on SNAP while on SSDI?
Don't know the answer to that. Best way to go there is to your township. Townships are wonderful things in Illinois, and people don't take enough advantage of them, but every township has a social services caseworker to help with SNAP and LIHEAP and SSI and SSDI applications. They're some of the most underappreciated people in all of government. But if you go to your township caseworker, they'll be able to help you with that.
Thank you. Let's see. Next one says, my brother has bipolar disorder, but also struggles with marijuana use. Will this affect his application and chances for approval? He is very pertinent on using this to self-treat his symptoms, but also takes the medication prescribed by his physicians.
So marijuana is that gray area because of the legalization. Some judges get bent out of shape about its use. Most judges don't. I would make sure that he is telling his therapist honestly how much marijuana he's using, and the psychiatrist, so that it's in the charts. And then when we get to a hearing, the psychiatrist can say that the marijuana use is not a material factor in his disability. And it just helps keep him calm and takes the edge off some of the symptoms. But I would make sure the psychiatrist knows really accurately how much cannabis he's using, so that he can give a valid opinion when he gets to the ALJ level.
Thank you. That is not a question. Okay, this one says, what did you say was the percentage of SSDI cases won for mental health?
I don't know. I know generally overall cases winning and losing. I wouldn't know about mental health. Specifically, I'm sure those numbers are out there. I don't know them. We take a lot of mental health cases, more maybe than most other Social Security firms, but a lot of that is because of my passion for NAMI. So I don't know the answer to that. There's statistics probably if you go to the Social Security actuary reports, they probably have those statistics. I wouldn't know them. And so many cases are combined. It's a bad back and depression, or it's fibromyalgia and anxiety, or it's PTSD and nerve disorder or something like that. So sometimes it's kind of hard to figure which was the one that was really totally disabling.
Thank you, Jeff. We have 2 more questions.
Let's do those 2, and I want you to be able to enjoy your family and call it a
Okay.
You're working overtime now, and I appreciate that.
That's okay. No worries. Important questions that need to be answered. So I'm happy to do it. 2 more questions. It says, I am a new community mental health worker / therapist and will need to help clients apply for SSI / SSDI. Most of my clients are low income. I'm worried I won't do things correctly. Do you have any advice for me to make sure I do this process correctly? And are there trainings available for somebody like me?
So there is a whole program available for counselors and therapists to help people with SSI, and it's called SOAR, SOAR. And I know a lot of the people in SOAR, and it's very, very effective. And you should get SOAR training, and that would help you out a great deal. Alternatively, just refer and work with the local Social Security firm, whether it's mine or any of the others, whoever you're comfortable with. If your professional time is better served working with clients than it is filling out forms for hours on end, let the people that do that as part of their cost, being the Social Security law firm, do it so that you can focus on the professional treatment side. That's entirely your call. Like we said, nobody has to pay money up front to a Social Security attorney. They only have to pay a fee if the claim is approved. But if you really want to do this, then absolutely take SOAR training. It's wonderful. But this is time-consuming work. And like I said, we have 1.5 full-time people on our staff who only do applications because it takes time to do them right. And if you have any questions or problems as a professional, just call me. Just call and just say you heard me speak and you had a question for me. They're going to try to route you to some of my team members in the law firm, but just tell them that, you heard me speak and you want to talk to me personally, and they'll usually take a message and I'll get back to you. Just say that you're a professional calling with questions, and I'd be happy to talk to you.
Thanks, Jeff. That's nice of you to offer that. Okay, last question says, can you please discuss benefits of ABLE accounts for additional funding of required benefits allowed and covered?
So now you're getting really into the weeds on ABLE accounts, which is a little beyond my expertise. But basically, SSI is supposed to pay the basic support, room and board, but you may need a new winter coat. You may need a new computer for school. You may need to buy a new bed and you can't afford a new bed because yours broke. ABLE accounts can be used for those basic needs. They're really, really a good tool. They're not well used yet. So I would definitely work with a special needs attorney on how best to set that up and to document how you use that money. But it's a really good way for families to divert assets to somebody without them losing benefits.
Thanks, Jeff. And somebody actually put in the chat saying that Turning Point can also help. So if you need another reference, you can call Turning Point as well to help with that.
We share office space at NAMI with Turning Point, and we're very, very proud of that relationship and really appreciate all the work that Turning Point does for people.
Yeah, totally. Yeah, that was wonderful. Thank you all for all of your questions. If for any reason we didn't get a chance to answer them, again, Jeff's information is located on the screen. You can also email me too at bhoekestra@namiccns.org, and I will relay those messages to him. Again, if you wouldn't mind, please taking the survey when you hang up the phone. It really does give us a lot of good information to continue with our funding, and also just tell us how we're doing and see if we need to make any changes moving forward. So thank you, Jeff. We appreciate you, and thank you all for coming tonight, and we hope to see you on August 30th for our next webinar. Please take care of yourself and each other and have a great night. Bye, everyone.
Thank you, Bree. Really nice job. And thank you for being my psychiatrist, too.
Totally.
Good night, everybody. And please do the surveys. Those are important.
Yes, yes, they are. All right,
Thank you.
everyone. Have a great night.
Good
Bye.
night.